Welcome everybody. Australian Government and Statutory Interpretation. Topic 5, the courts. Doing something a little bit different this week. We're going to do InSight Bytes. Just diving down into topics for you to remember. I'm going to start off with the Australian judicial system. You can appreciate there's a hierarchy of courts, and we have the High Court of Australia sitting at the very top of that apex. Prior to 1986, even the High Court itself would appeal to the Judicial Committee of the House of Lords, known as the Privy Council, for ultimate decisions as part of Empire history. But post 1986, we can now say the High Court is the highest court in the Australian judicial system. Not all courts in Australia can hear all disputes. There are legal rules determining what disputes which different courts can hear, and we call that authority to decide a matter a jurisdiction. Courts then exercise their powers to resolve disputes before them. There are two main types of jurisdiction: original and appellate. Original jurisdiction is the authority to decide a dispute at first instance. You can bring your matter to the court and they will decide a dispute. Appellate jurisdiction is the authority to hear an appeal from a decision of another court within the judicial hierarchy, usually lower down, and the ability to overturn. If there's been an error made, they can uphold the appeal or they can dismiss the appeal. The state and federal judicial systems interact in various ways. The state courts can be empowered to exercise federal jurisdiction. And the second way is that the High Court sits at the top of all the others. It's Australia's highest appellate court. And it obtains this jurisdiction from the Australian Constitution. In other cases, there's legislation which sets out which court can hear appeals from others. So we're going to call that an integrated Australian court system, because ultimately all appeals, if granted special leave to appeal, end up in the High Court of Australia. As we said on the first slide, High Court sits at the apex with other courts underneath. In red is the Victorian court hierarchy, and as you can see in blue is the federal court hierarchy. Down the bottom of the lower courts, VCAT, which is actually a tribunal. We have a coroner's court, got the children's court, the Magistrates Court of Victoria for summary offences and some indictable offences, and jurisdiction to hear matters up to $100,000. County Court for more serious offences and indictable offences, matters up to $200,000. And then the Supreme Court of Victoria, which has a trial division to hear serious murder trials, for example, in the first instance, and then a fuller bench would constitute a court of appeal. And as we've seen, you can appeal up if you can secure special leave or permission to the High Court of Australia. On the right, we've got federal courts. There's the Federal Circuit Court and a Federal Court and the Family Court. All of Australia's federal courts ultimately derive their powers from Section 71 of the Australian Constitution, providing the judicial power of the Commonwealth shall be vested in a federal Supreme Court to be called the High Court of Australia, and in such other federal courts as the Parliament creates, and in such other courts as it invests with federal jurisdiction. The High Court shall consist of a Chief Justice and so many other justices, not less than 2, as the Parliament prescribes. So section 71, important. Not much guidance on what judicial power actually means, but we'll have a look at that shortly. It requires the establishment of a High Court and also contemplates and allows Parliament to create other courts. So let's have a look at this jurisdiction of Australia's federal courts, so the kinds of matters that they are empowered to hear. Under section 73 of the Constitution, the High Court has authority to hear appeals from the state Supreme Courts. So it has appellate jurisdiction under the Constitution. Section 75 of the Constitution gives the High Court original jurisdiction to hear matters arising under any treaty and matters which the Commonwealth or someone being sued on its behalf is a party. 75, subsection 1 and 3. The Constitution, under section 76, authorises Parliament to confer additional original jurisdictions on the High Court. So, this slide and the last shows us some constitutional provisions confer jurisdiction directly on the High Court, 75, whereas 76 gives Parliament the power to decide whether to do so. 2 different types of authority. The High Court of Australia then playing a unique role in our judicial system, then original jurisdiction to hear matters. If anyone's suing the government, that's the court for it. And also permission, appellate jurisdiction to hear appeals from all of the state Supreme Courts. So this is great. It creates an integrated justice system, doesn't it? Because we've got federation, we've got state-based power, but then we've got a government federational power, separation of powers, executive, legislature, courts, and Section 35A of the Judiciary Act 1903 allows all state Supreme Courts to ask permission, known as special leave, to appeal up to the Court of Appeal, to the High Court, and that then creates a unified court system. It's a bit of magic. It turns a state-based federation, state nations into a federation judicially with this provision, section 35, because it knits it all together. All right, so you need special leave for appeal. You can't just apply unless you can satisfy this section. The High Court may have regard to any matters that it considers relevant, but shall have regard to. So this is not exclusive, this is an inclusive list, section 35A. Subsection A, whether the proceedings in which the judgment to which the application relates involves a question of law, one that is of public importance, so it's serious implications, whether it's because of general application or otherwise. 2, subsection 2, in respect of which a decision High Court as the final appellate court is required to resolve differences of opinion between different courts. And subsection B, whether the interests of the administration of justice, either generally or in a particular case, require consideration by the High Court of the judgment to which the application relates. So you need to, in your special leave application to the High Court, you need to frame it that it's of public importance, or it's necessary to resolve an ongoing dispute about the application of the law, and or it's important for the interests of administration of justice in general. So it's a great thing. It can pull it all together under one apex, one ultimate High Court of Australia. So the Constitution allows Federal Parliament to create other federal courts, and it has done so. It's created the Federal Court of Australia, the Family Court of Australia, and the Federal Circuit Court, each created by federal legislation. These courts all derive their power from Section 71 of the Constitution, but their jurisdiction is set out in federal legislation. So what's important to note is while the Constitution allows Federal Parliament to create federal courts, it doesn't require them. So technically, the Commonwealth Parliament could abolish all federal courts. However, this is different with the High Court, do you remember, which is required to exist by Section 71. Now, that means that the Parliament cannot dissolve the High Court. So isn't that interesting? Now you might think, why is that? Have a think. Pause the slideshow and think, why do we not want Parliament to be able to dissolve the High Court? So the question was, why don't we want Parliament to be able to dissolve the High Court of Australia? You guessed it, separation of powers. We don't want Parliament to have all the power in our legal system. We want to split it. And as you know already, we don't have, this diagram's a bit simplistic, isn't it? Because Parliament is also made up of the executive government. So already our executive have voting power in the Parliament. So already there's a slight blurring of separation of powers where the executive government also sits in Parliament. If they then also had power in Parliament to make a law to abolish the High Court of Australia, then you've pretty much vested all power in Parliament and by definition the majority government and the cabinet of that. So you're top of the executive and the majority of Parliament would have all the power in Australia. All right, so constitutionally enshrined under Section 75 and Section Judiciary Act 1903, Section 39B. So 75 of the Constitution says, in all matters in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth, the High Court shall have all original jurisdiction. So there's constitutional power, Section 75, to give the High Court original jurisdiction to check the power of an officer of the Commonwealth, so the executive, and that's mirrored in the Judiciary Act Section 39B. The original jurisdiction of the Federal Court of Australia includes jurisdiction with respect to any matter which a writ of mandamus or prohibition or an injunction is sought against an officer or officers of the Commonwealth. So again, we've got a legislation authorising the Federal Court and constitutional power authorising the High Court, both of them to check and hear matters in which a remedy is sought against an executive officer on the basis that they've gone beyond the power vested in them by statute, by Parliament, and that they therefore acted unlawfully. So we've got powers to check government executive action, and likewise, as we'll see, Parliament doesn't overstep by trying to legislate beyond their power, as we saw in Chapter 1 in the Communist Party case. You remember where the government tried to outlaw a communist political party. All right, excellent.